Thank you, everyone, for participating in today's webinar. We're very glad at the Victim Rights Law Center to be able to have an opportunity to focus on privacy issues that impact sexual assault nurse examiners in Oregon. I'm Carol Schrader. I'm a staff attorney with the Victim Rights Law Center, and where I work on various privacy-related issues, providing technical assistance and training to Office on Violence Against Women grantees. Jessie, would you like to introduce yourself?
Sure. Thanks. Hi, everyone. Good morning. This is Jessica Minlin, also with the Victim Rights Law Center. And like Carol, I'm based in our Portland, Oregon office, where we both provide free legal services and do national technical assistance.
Thanks, Jessie. So today's learning objectives are that by the end of the webinar, those of you who are participating will be better able to identify at least 4 privacy concerns specific to rural sexual assault survivors, list 4 types of patients whose injuries or abuse are subject to Oregon's mandatory reporting laws, explain mandatory reporting in Oregon, identify Oregon's nurse privilege and confidentiality laws, and be able to describe informed consent. Let's start by taking some time to think about why survivor privacy is important. We want to ask you to please use the chat box to share with everyone participating what are some reasons why you think survivor privacy matters. And when you're thinking about why it matters, please focus on why it might matter, especially if it does in rural areas. So we'll give you a moment to identify some ways in which survivor privacy is important. And when we're talking about survivors for this webinar, we are focusing on sexual assault survivors. Okay, so I see that one of you has identified the importance of making sure that someone who's perpetrated sexual assault doesn't find out about what's going on with a survivor. And that's something that I often frame as a safety concern. And I think that how that plays out in rural areas is if someone reports that they saw a survivor at the hospital or saw their car parked somewhere, that word gets around. One of you has identified the importance of providing victim or survivor-centered services, and that can be really important as far as allowing for survivors to control their own narrative and their own information. So in rural settings where everyone knows everyone else, that can be an important issue. And then those 2 issues, autonomy and safety, are also related to recovery. I see that one of the issues brought up is that people will come to your services only if they trust that you can keep things confidential. So having sexual assault forensic exams done, it would be important that word doesn't get out about anything that happens during that exam. And ways in which these issues that you've identified, thank you, can be heightened or perhaps threatened in rural areas can come up with issues around transportation. As we talked about earlier, you can know whose car is in a parking lot, or if someone's seen at a hospital, most people or a lot of people are going to know the people they see there in a small community. And advocates and law enforcement are likely to know survivors or perpetrators. So that's part of why it's really important to keep information confidential. Jessie, do you have anything you want to add to why survivor privacy matters, especially in the rural context?
I think you touched on a lot of those points, Carol, but I guess I might summarize all of that by saying that survivors tell us it matters to them. When survivors have been surveyed about why they made a decision, for example, not to report to law enforcement, the #1 reason that they cite are their privacy concerns, that they don't want friends or family members, partners, etc., coworkers, to find out about the victimization that they experienced. And so it's really at the heart of providing, as you said, Carol, survivor-centered services, is making sure that we are doing everything we can to promote survivor agency and autonomy, and to allow them to control who has what information about them to the extent possible.
Mm-hmm. At this point, I'm going to turn things over to you.
Great, thank you. So now that we know that survivor privacy matters, it's also important to talk about some of the ways in which there can be breaches in the healthcare context. And I just wanted to share some examples with you all of ones that I found quite easily just by doing a little bit of research on the internet. One was a finding that a state hospital was sanctioned because, as you know, summarized here, it was a nurse and an orderly. It was at a state hospital who were discussing the HIV or AIDS status of a patient, and that patient's spouse was within earshot. And there were other patients that also could hear, and that it was determined that really the folks involved, the nurse and the orderly, did not take sufficient steps, and they did not exercise reasonable care to make sure that their conversation about this patient was not overheard. And again, particularly in communities that are very small or insular, where everyone knows everyone, it's so important to be sure that you are having any kinds of conversations in a confidential manner as possible. Another complaint that was adjudicated was that a patient had specifically requested that information not be left on their home phone, but that they be contacted through other means, and that just someone didn't pay close enough attention and left a message on the patient's home phone. A third example, which is one that may come to mind for many of you, you may remember in the Kobe Bryant case, that the victim's records in that case had been subpoenaed by Kobe Bryant's attorneys. And there were actually sort of several things that happened, and one is that a hospital employee released all of the records to the judge, to the court. That was much broader than what had actually been initially requested in the subpoena. I'll note that they were also, I believe, turned over to the district attorney's office. That did not go through all of the records before that they were shared. And there was records from other hospitals, other providers that were also disclosed to the court and ultimately to defense attorneys. And then even further, it ended up, of course, being shared with the media. And that was a case where there were just really multiple breaches, all stemming out of what was the scope of the initial request for the victim's records and what was ultimately disclosed. This next one, it was one of those reality TV shows, and they were doing filming. The hospital allowed the filming to take place in the hospital. They did not get the consent of patients, and it was the family of someone who had died at that hospital who recognized their own family's voices in the background from the taping that occurred, and the hospital was fined, as you can see here, several $million. And last but certainly not least, it became very kind of a subject of widespread discussion when the University of Oregon released the private, confidential, and privileged counseling records of a student who had received counseling services at the hospital to the president of the university and also to their outside counsel. And in that case, they specifically informed the clinic director not to inform the client and not to inform the therapist who was providing the services. So those are just some examples where the breaches are intentional of survivor privacy, where the breaches of a patient were unintentional, but really just kind of wanted to underscore for you what some of the consequences can be in terms of sanctioned. And this is just another example. There was a physician, an OBGYN, who was really frustrated and took to Facebook, to social media, to post and say, I have a patient who's either chosen to no-show or to be late, sometimes by hours, for all of her prenatal visits, for ultrasounds and STs. And the physician posted and said she's now 3 hours late for her induction. May I show up late to her delivery? And obviously just feeling super frustrated. And because I'm a privacy geek, I blacked out sort of what the identity were of all of the other folks, the physicians who replied, most of them, and you can see where they're from for some of them. And the doctor replied and said, well, I agree with sort of, you know, not I agree, I'm sorry, but rather explains in there that here's the explanation of why the physician has put up with this patient, and said that the reason being that they had a prior stillbirth. Well, there was someone on Facebook who saw the doctor's posting who recognized who that patient was, and the doctor did immediately take it down from Facebook. But at that point, it was too late. The patient's privacy had been breached, and ultimately what happened was that the physician was fined, and perhaps more importantly in terms of their career was that they lost their admitting privileges to that hospital. So those are just sort of a few examples, not necessarily in the survivor context, but some of them are. Well, we wanted to share with you some of the questions that we often hear in our capacity as national TA providers for Office on Violence Against Women grantees. You know, and the first is, must I, as a healthcare provider or as a SANE, report a sexual assault? Another question is, do I risk nurse-patient privilege if a victim advocate is present during an exam? May I examine a teen without a parent's permission? Do I need the permission of a parent or a guardian? What should I do if I'm asked to testify at a school disciplinary hearing? And does reporting information to a police officer violate HIPAA? And we'll be providing some answers to some of these questions, but we wanted you to get a sense of some of the questions that are posed to us that we are available for OVW grantees to provide support around. And the answers to some of these questions are going to be informed by patients' expectations, the assurances and the representations that you give to them, as well as your ethical, your licensing obligations, and of course any federal or state or tribal laws that may govern. And by laws we're referring here both to statutes, to the laws that get passed, and also the law that is created by judicial decisions. So we want to talk a little bit about privacy and confidentiality and privilege, because we often use these terms interchangeably, but there's some very significant distinctions between these concepts in terms of legal protections that are especially relevant here in Oregon, where our statutes distinguish between them. We often describe privacy as a general expectation that we will respect and protect information that is shared with us. That may be an expectation of privacy between friends, between partners or spouses, family members, and then of course with patients as well. But confidentiality is how that privacy is sort of protected in a way that is required by your ethical obligations, and also, excuse me, here in Oregon, by statute, because there are specific statutes that establish those communications between a healthcare provider and their patient as protected. And then even sort of further protected, but with specific standards in the law, is privilege, and which applies to privileged communications. And privilege is established by statute. In other words, there's a law that says these are privileged communications between these individuals and these professionals. And it is essentially a rule of evidence. So privilege governs what information may or must or may not be admitted into evidence when there is a court case. So we're going to turn now to a discussion of nurse and patient confidentiality and privilege here in Oregon, and I'm going to turn it back to Carol.
Thanks, Jessie. So Jessie gave an overview of how privacy confidentiality and privilege work generally speaking. And what we're going to do now is look at what Oregon law says specifically about nurse-patient confidentiality and nurse-patient privilege. So in Oregon, the Oregon OARs state that the licensed nurse, quote, protects confidential client information and uses judgment in sharing this information in a manner that is consistent with current law. So what we see here is a general need to protect confidential information, and that if any information is being shared, it needs to be consistent with the current law. So we're going to look in detail about that in a moment. But continuing our overview of what Oregon law says about nurse-patient confidentiality and privilege, when we look at the privilege statute, it reads, a licensed professional nurse shall not, without the consent of a patient, be examined in a civil action or proceeding as to any information acquired in caring for the patient. So that information is protected in a civil action or proceeding. We receive questions about how this might apply in criminal proceedings in Oregon, and the answer to that is not as clear as it might be. The Oregon Evidence Code applies generally to civil actions, criminal actions, and to contempt proceedings, and the law of evidence in civil actions is also the law of evidence in criminal actions and proceedings, except as otherwise specifically provided in the statutes relating to crimes and criminal procedures. And that's where it gets a bit complicated, that last part about the statutes relating to crimes and criminal procedures. And I think it's not only those statutes, but case law and judicial perspective. So the question of how this privilege works in criminal proceedings is not as clear as it might be in Oregon. So the privilege belongs to the patient when we're discussing a nurse-patient privilege, and it becomes up to the patient, ideally, and in most cases, whether or not that privilege is waived. And as a starting point for this discussion, I'm going to read the statute that has to do with waiver of privilege in Oregon. A person upon whom Oregon law confers a privilege against disclosure of the confidential matter or communication waives the privilege if the person or the person's predecessor while holder of the privilege voluntarily discloses or consents to disclosure of any significant part of the matter or communication. So the patient in this case is the holder of the privilege. So if they voluntarily disclose information that was in what I consider the cone of silence that surrounds privilege, that zone in which a confidential communication is made within that is privileged, if the patient discloses information or allows for a significant part of that information to be shared, then the privilege having to do with that significant part of the matter or communication is waived. It no longer stands, and information that had been privileged that no longer is privileged could be released in a judicial proceeding. So we've focused a lot on the importance of confidentiality and privilege when we're thinking about the importance of survivor privacy, of keeping things private. And on the other side of that is mandatory reporting, where information is required to be disclosed. So we're going to spend some time looking at that because mandatory reporting can threaten survivor privacy. In Oregon, we have various mandatory reporting laws, and you'll have these laws on the materials, the PowerPoint presentation materials, but I just want to highlight them for you now. Oregon has mandatory reporting of child abuse. We also have mandatory reporting of elder abuse, abuse of a person with a disability, a serious non-accidental injury, and we're going to, Jesse's going to go into some detail about that reporting and of reportable diseases or sexually transmitted infections. And within these, for example, excuse me, with the child abuse law, nurses are specifically identified as people who have mandatory reporting obligations. So with each of these mandatory reporting laws, you would need to examine and see whether or not you are a mandatory reporter of these types of abuse. And that would be the first question that you would need to ask as you think about whether or not you have to report abuse or an injury that you encounter in your work as a sexual assault nurse examiner. And one way that we think about that is, so I get a little teary just thinking about it, the idea is that you need to peel back a layer and you don't get to the next layer of the onion until you've peeled back the outer layer. So the outermost layer of the onion is asking, are you a mandatory reporter? In Oregon, with most, if not all, areas of mandatory abuse, the answer is probably yes. And then the question is the person who's been injured or abused someone whose abuse must be reported? So you might think they fall within the category, but as Jesse's going to work you through, you need to be sure. And there are questions that you would need to ask to know whether or not this person whose abuse or injury must be reported in Oregon. And related to that is, has the victim experienced abuse or injury? And once you've gone through, answered those three questions, if you answer yes to all three of those questions, then you would need to know if you're exempt from reporting, and typically that would be, for example, attorneys in Oregon. So it would be something you would look at, but probably does not apply to you. And then the last thing is, what specifically is required to be reported under the law? So we'd like to go in, whenever we're looking at whether or not someone needs to report something, if they fall within the mandatory reporting law, we go through this inquiry. And now Jesse's going to give you an example of how that works when looking at non-accidental injury reporting.
Thanks, Carol. So I get to be sort of the counterpoint to the points that Carol was making, which is, on the one hand, you may have waiver, which is when a patient, and hopefully in as informed manner as possible, voluntarily and intentionally decides to waive their privilege. In other words, to step out from the protections of their privilege. And then, of course, at the other end of the continuum, we have these circumstances, such as mandatory reporting, where really regardless of what the survivor may want or may wish for in terms of privacy, they don't get to have that information remain private once it's been shared. Now, sometimes folks will say, oh, could you just do sort of, a mandatory reporting made simple kind of presentation? And I often kind of laugh and think, well, actually, part of our job here is to say it is way more complex than it might appear at first blush. Like you think, okay, this is pretty, straightforward. We have these statutes, these mandatory reporting obligations, and you just read them and then you follow them. But as Carol just said, we really go through sort of a very kind of rigorous inquiry whenever this question comes up, because it is so much more complicated than it appears. So we know that there's lots of training that's provided around child abuse reporting or elder abuse reporting, and we thought that we would break down and delve deep, as it were, into this discussion of mandatory reporting for healthcare providers around non-accidental injuries. So we want to start with, what does the Oregon statute say? That's the ORS. It stands for Oregon Revised Statute. And what ORS 146.750 says is, in relevant part, a registered nurse who has a reasonable cause to suspect that a person brought to or coming before the nurse for examination, care, or treatment has had injury, as defined in ORS 146.710, inflicted other than by accidental means. So you think, okay, that's pretty straightforward, right? I have to report when someone has an injury that is by essentially non-accidental. Well, they tell you right here in this statute that there is actually a definition in Oregon law for how the term injury is defined. So if you were reading this statute, you'd say, hopefully the first thing would come to mind is, okay, I better go look at what ORS 146710 to see how injury is defined. So let's look at that. Oops, got ahead of myself here, sorry. 146710 gives us a definition of injury. It's either, 1, a physical injury that's caused by a knife, gun, pistol, or other dangerous or deadly weapon, or 2, a serious physical injury. And as you might have sort of guessed by now, that I'm going to say, okay, well, what is a physical injury? Or what's a dangerous or deadly weapon? And what's a serious physical injury? I need to know those definitions to know whether or not this quote-unquote injury that the patient coming before me has had inflicted on them is something that is subject to a mandatory report under Oregon law. So I need to know, is there a definition? Let's start with the question around dangerous or deadly weapon. I don't know if there's a definition of that, so I do my internet search. And I just put into, sort of my internet search engine, okay, what's a deadly weapon? It could be dangerous, it could be deadly. I just went with deadly for this example. And I see immediately that it comes up that there are some general definitions. So there it is, deadly weapon. It means any instrument, article, and I'm going to go to that statute. And here we have a definition, in fact, of both dangerous and deadly weapon. It says, here it is for a definition of dangerous weapon. Here we go is our definition of a deadly weapon. And I'm not going to dwell so much on this here other than to remind folks that when you are confronted with this situation, you're going to want to go back, you're going to need to go back and look at the definition. So now we have our definitions of dangerous or deadly weapon, but we still need to know more because it was either physical injury plus dangerous or deadly weapon or a serious physical injury. So I'm going to pose the same question. What's the definition under Oregon law, if there is one, of a serious physical injury? And once again, the internet comes through for me, and I find the statute. Right, of what is a physical injury, because it was physical injury plus dangerous or deadly weapon, and also what's the definition of a serious physical injury. And Oregon law provides those definitions. Now, I want to point out that we are now at the place where we have a definition for physical injury, for serious physical injury, for dangerous weapon, and for deadly weapon. And all of these terms are critical to helping establish whether a patient who's come before you for care has suffered an injury that was caused by non-accidental means. And yet the statute didn't say that you had to kind of go down this rabbit hole of acquiring all of these definitions in order to go through the analysis that Carol just walked you through, the peeling back of the layers of the onion. But in fact, they are necessary and critical to knowing whether or not the patient who's before you has a suffered injury that is subject to the mandatory reporting laws for healthcare providers in Oregon. So we're going to turn to a video. I want to give a shout out and a thank you here, first of all, to Joanne, who is the survivor who's going to share her story with us today. And also our thanks to the Oregon Attorney General's Sexual Assault Task Force, who did a series of interviews with sexual assault survivors in Oregon about their experiences and has shared those videos and made them available for training purposes. So I want to both acknowledge and thank Joanne and the Sexual Assault Task Force. And then I know all of you participating on this webinar this morning are sexual assault nurse examiners. You know, you work routinely with sexual assault survivors, but just a reminder to take care of yourself, both during this webinar and afterwards as you hear Joanne share her story. And while we're getting the video ready to launch, I want to pose three questions for you to think about as you're listening to Joanne share her story. What privacy issues can you identify? what witnesses even maybe do you think might be called? What did Joanne believe regarding her patient privacy, and whether you think under Oregon law this would trigger a mandatory report. So I'm going to go back, and we're going to take the next 5 minutes to have you watch the video of Joanne, a sexual assault survivor, sharing her story.
My name is Joanne, and my assault occurred in Washington County. My sexual assault occurred on a date, and I had had contact with that person for about 2 months leading up to the date. I felt like I knew the person enough that I didn't feel like they would be unsafe. Went on a date, had a drink, and left my drink on the bar. And when I came back from the bathroom to ironically do my check-in with my date friend, you know, I always had a safe friend that I would call, I drank a little bit. There was a new drink there, and I drank it, and I felt sick. I mean, I felt really sick within about 5-10 minutes. And we had walked down to another part of the establishment that we were at, and I could barely walk by then. And I went to the bartender and asked him for some water, and I couldn't explain, but I was like seeing double by then. And the bartender gave me some water. I don't remember a lot of what happened the next hour or so, but the part that I started remembering was that I was in a car and I was getting the crap beat out of me, and you know, it just progressed to a sexual assault. I couldn't get out of the car. The doors were blocked. I was in the back of the car. And I was able to talk my way out of that car. And so I didn't go to the police right away. I went to work the next morning. I took a lot of ibuprofen. Went to work, and I teach, so I have to stand a lot, and I couldn't get through my day. I had handprints and punch marks all over me. And I remember my teacher's assistant going, "Joanne, what is wrong with you today?" And I just said, you know, I gotta go home. And I drove home, tried to still keep my routine for my kids, brought them to youth group that night, and then I still was like trying to keep control of my schedule and of my life, and try to fit in help for myself. So then I went to I still had not told anybody what had happened. I went to the hospital, and I didn't even know how to tell the charge nurse. I remember at the ER, they're like, "Well, why are you here?" And I just froze, because I think that was the first moment that it really hit me. I was really there because I had been raped. And I tried to say it. I couldn't say it to the nurse. So I asked for a piece of paper, and she's just looking at me like it was so like, what is this lady doing? I don't know what she was thinking about me, but she just looked at me strange. So I wrote it down, and I said, "I'm here because I was raped." And that is the first time that I told anybody. And then I saw the rape. They had a special nurse that worked with me, doing the exam and everything. But I was so ashamed of the situation, and being in a situation where I could be raped. And I just wanted it to go away, but I knew that my injuries were enough that I had to get some medical help, because, you know, I had been bleeding. I had just beat marks all over me, and I knew I needed help. And I know that the nurse was great. She asked me lots of questions, and they sent a sexual assault resource gal to the hospital to talk with me. And honestly, I still mentally was still at a place where I just didn't want to talk about it. I was okay with the nurse because I felt a little safer with the nurse, because I knew that she was legally obligated not to tell anybody. So in the back of my head, I was like, okay. And then you have this other person come in who I know was trained, but it was just so humiliating, because they're taking pictures of you. They're you know, they're taking pictures of every area of you, and they're diagramming the bruises and the injuries, and you kind of feel like you're in this petri dish, and then everybody wants to talk to you about how you feel, and the very last thing you want to do is talk about your feelings, and because you want it, at least for me, I wanted it to go away, and then I felt like there was this pressure. Okay, well, you know, you don't want this person to get away with it, so you're going to want to talk to a police officer, and you know, we can have police officers there, and you know, up until the point that I wrote that down on the little note to the ER person, I really hadn't accepted that I had been raped.
Okay. So my thanks always to Joanne for being so brave and wanting also in sharing her story, and also in willing to allow all of us to learn from her experience. So let's go ahead and use the chat box, and we'll start with the first question of, you know, what privacy issues or what privacy considerations did you identify for Joanne that might arise if she were coming to see you for services? I'm just going to give you a minute to use the chat box, and I'll read them out as you will write. Great. I can see a number of you have listed things already, and others, it tells me, are still typing. Yes. So definitely what's going to happen with her medical forensic records. I will say her medical records and also from the evidence collection. Great. Yeah, there was the issue, good, that Joanne said that she immediately drank something and then felt sick. So if there is drug testing that's going to be done, making sure that you've got informed consent and that Joanne understands that if there is going to be drug testing, what, you know, any possible results that may come up, and if she decides to go forward and to have the kit shared with law enforcement, that information will be shared with law enforcement as well. Great. Yes, somebody identified, good, the note that Joanne wrote at the hospital when she got there and couldn't talk and needed to explain to the charge nurse why she was there. Definitely something, if there's a case going forward, that the note, and we don't know what happened to the note. Is it preserved as part of her file? Was it just recycled or tossed? But that's definitely something that is potential evidence. You know, some other privacy implications is what's in the records, what information is she sharing with the SANE. How did she communicate with the man who assaulted her? Mm-hmm. Yeah, by computer, by phone, those text messages. She said that they were in communication for about 2 months prior. And then also, if I were as Joanne's attorney or if I were an advocate who were working with Joanne, I would be thinking about, well, who are the potential witnesses that might be called? And yeah, the nurse, as you already mentioned, both the nurse, the SANE who did the exam, potentially the charge nurse to whom Joanne wrote that note, and then, of course, potential other witnesses I would be identifying and thinking about and working proactively to protect her privacy. With respect, like, for example, the coworker, her assistant teacher, her kids. Yeah, somebody mentioned the bartender. And, of course, Joanne herself. At the bar, there may be some kind of a security video that may have caught either what was transpiring in the bar and may provide some evidence or support for the fact that she was probably drugged in the bar, and also potentially where the car was parked in which she was actually assaulted. So those are all just some issues that we would be thinking about. And this question, what did Joanne believe regarding her patient privacy? What did she share with us in that video? Yep. That she, several of you have mentioned this, that Joanne believed that, she says, I was okay with telling the nurse because I knew she was legally obligated not to tell anybody. And she has assumed that any communications she's making with a healthcare provider are going to be protected by confidentiality, maybe by, she may even know the term privilege. And then, of course, the question of does this trigger a mandatory report, and you would need to be going through that analysis that we just walked through together in terms of the physical injury, plus did it involve some kind of a dangerous or deadly weapon or serious physical injury, and that's an assessment that you would need to go through. But hopefully that would not be news to Joanne. It wouldn't come as a surprise, but rather it would be information that would have been shared with her in advance of this is the extent to which we can protect your privacy. These are the mandatory reporting obligations that we have. And then in addition to mandatory reporting, there are also some other exceptions that exist, and Carol is going to be addressing those with you. I'm going to turn it over to you, Carol.
Thanks, Jessie. So up until this point, when we've been looking at the law, we've been focusing on Oregon's confidentiality and privilege and mandatory reporting laws. And in addition to our state laws, there are also federal laws that can come into play when you're working with sexual assault victims or survivors, and what information may or may not be shared. And I would think that at this point, the Health Insurance Portability and Accountability Act, commonly known as HIPAA, comes into play. And there is a lot going on with HIPAA and related law. Jessie and I are not HIPAA experts, but there are some law enforcement exceptions and related exceptions that we wanted to highlight for you so that they could be in your mind as you do the work that you do. And so we're going to focus on some of those now. There are, under HIPAA's law enforcement exceptions, some disclosures of information that are permitted. And those disclosures include when law requires the disclosure. So for example, mandatory reporting law and the sort of things we've gone over so far in this webinar. Another permitted disclosure is when that disclosure is ordered by a court or when it's required through a subpoena issued by a judicial officer or administrative body. I want to highlight here that generally under HIPAA, and I'll use this particular disclosure that we're on at the moment, that the disclosures are limited. So, for example, with the subpoena-related permitted disclosure, only the protected health information expressly authorized by such order may be released. So I think back to the example Jessie gave about the Kobe Bryant case, where there was a subpoena that requested certain information, but then more information was released than that which was required to be released. Information may also be disclosed under HIPAA if it's necessary to identify or locate a suspect, fugitive, witness, or missing person. If the victim consents or is incapacitated or there is an emergency, that information may be allowed to be disclosed. There are permitted disclosures related to a suspicious death, if there's a crime on the premises, or there's a medical emergency related to crime off the premises of the covered health care provider. And these are brief issue identifying summaries of the issues. So if you're wondering about them, I encourage you to go to the Federal Code of Federal Regulations, 45 CFR 164.512, and look at those so that you can get the full sense of what is permitted and the limits that are put on those disclosures. As far as this is not an opening the floodgates of disclosure, but certain specific limited information may be released. So how might this play out? Here are some questions, and we'll give answers to the questions about how HIPAA comes into play. So the first question is, if there's no subpoena, how much information, if any, do I give to law enforcement? And I want to start with a reminder that if there had been a subpoena, that one would only release the protected health information expressly authorized. Under HIPAA, though, there are requirements of when information may be released to law enforcement without a subpoena. And the first one is a court order or a court-ordered warrant or subpoena or summons from a judicial officer. The second is a grand jury subpoena. And the third is an administrative request, information that is thought is relevant and material. The request is specific and limited, so even in this situation there are parameters put on how much information may be released, and de-identified information couldn't reasonably be used to get the information that law enforcement needs. So you can see, even though there are permitted disclosures, there are parameters put on them, and it's very important to know those parameters so that they can be honored in your practice. The second question is, do I need a victim's permission to call an advocate to the hospital for patient support? And our answer to this question is based on the presupposition is that you don't need to reveal a victim's personally identifying information to call an advocate to the hospital, so that you wouldn't be releasing any personal health information to say, we have someone at the hospital who could use an advocate's support. So our answer to that question is a qualified no. And if the victim's available to ask whether they want to have an advocate come to the hospital, should certainly be part of your consideration of your answer to that question. The next question is, and I'm going to frame it a little more specifically, is may a minor in Oregon, may a minor consent to a forensic exam? And the answer to that question depends on the age of the minor. In Oregon, teens who are 15 or older may consent to hospital care and medical or surgical diagnosis or treatment. So certainly minors 15 and older may legally consent to a forensic exam. And lastly, do I have to testify at a campus disciplinary hearing? And the answer to that is that testifying at a campus disciplinary hearing does not fall within the permitted disclosures identified under HIPAA. So the answer to that would be no, unless a patient has asked you to participate in that disciplinary hearing, and in which case you certainly could do that if you have informed consent. What do I mean by informed consent? I want to say that in our work, we're working with OVW grantees. We look at what the Violence Against Women Act and other federal requirements are for grantees. And although we expect that you as Oregon sexual assault nurse examiners are not grantees of these federal programs, they set out what's best practice for informed consent for a release of information from a patient in the context of a sexual assault forensic exam. The best practice would be that the release would be in writing, that can generally help patients make sure that that you and the patient are on the same page about what's being agreed to, and then when questions come up later, you can look back at the agreement that you've made. And in order to get to that written agreement, generally what is required under the VAWA confidentiality requirements is that you would first discuss what you're wanting to, what you're asking or would be sharing on the patient's behalf, have an agreement about that, and then record the agreement, and that would be part of that written informed consent. There needs to be a specific agreement about the information, so general blanket releases that allow you to share things like client medical record or broad information about the patient. I should have said patient earlier, so about a patient's medical record. that it should be specific information. So it would be information about the forensic exam which took place on this specific date, or maybe a particular section of that record. But that's the sort of thing that you should discuss with the patient before signing the release of information, to make sure that everyone's on the same page and that there isn't an oversharing of information. The consent should be time limited. It shouldn't be for an open-ended consent, and the length of the consent will depend on the circumstances. If you're getting a release to talk with someone that afternoon, say a survivor's advocate, then it may just be a one-day release. If you're needing a release in order to acquire records or share records that will take a while to get, given how the administrative process works, then you would need a longer period of time. So it's very circumstance dependent. And the consent, in order to be informed, needs to be in a language that is understood by the patient. And the consent should be revocable at any time. That revocation does not need to be written. And the implications of sharing the information need to be clear. We've talked about the confidentiality and privilege that nurses have in Oregon. But when you're sharing that information with someone else, they may not have a privilege. They may not have privileged communications with that patient, so that protections may not be there, and in fact you may be waiving the privilege. And so a patient needs to understand that before the information is shared. So Jesse, do you want to weigh on anything else about informed consent before we move on to some general survivor privacy tips?
No, I don't think so. I think you've really covered it all, Carol. You know, and again, just to summarize that informed consent is at the heart of what we are wanting to offer survivors to help, you know, promote their sense of agency, autonomy, control, self-determination, all of things that were taken away from them when they were assaulted. Mm-hmm. So we wanted to share with you just some tips or I guess precepts to hold on to in doing the amazing and wonderful work that you do. And the first is, of course, know when you are and are not mandated to report, whether that's child abuse, elder abuse, non-accidental injuries, but going through that careful and thoughtful analysis that we walked you through in the context of non-accidental injuries, but for each of those other areas. Because sort of just a kind of a facile review is probably insufficient, or it may be insufficient in any particular circumstance to know whether or not this specific set of circumstances that this individual patient experienced falls under your mandatory reporting obligations under Oregon law. And then it's just, of course, really important to discuss both the confidentiality that you can extend to your patients and also any limits on that confidentiality with them at the very outset. And I know sometimes folks will, you know, give us some pushback and say, yeah, but then they won't report. And we're like, well, yes, exactly, because that is, you know, again, it's the patient first, it's the survivor first. It's the heart of that survivor-centered services is that they're able to make those informed decisions. And some of that is not over-promising. I think sometimes that we can say, whether in the advocacy world or the attorney-client world or the healthcare provider, patient world, or everything you tell me is confidential. Well, as we've just walked you through, there are those exceptions, and depending upon who is the patient population that you're serving, they may apply to this particular patient that you're caring for. So just taking care not to give assurances that you can't follow through on. And particularly in population-specific communities where you are either using interpreters to communicate verbally with the patient or translators in the context of documents, that you always want to be thoughtful about the survivor's privacy needs and their privacy rights. And again, particularly whether it's rural communities, small communities, population-specific communities, any of these can be very insular where people all know each other. And if you are using, whether it's internal or external interpreters, for example, let the patient know who it is that you will be using. You just pause for a moment, find that out, and ask them whether they know this person or whether they're okay with you using this person. And sometimes I will share just a very, very difficult experience that happened to a lawyer colleague of mine at a different organization with an interpreter who it turned out knew both the husband and the wife in this marriage that was being dissolved. And apparently when the attorney was out of the room was saying just terrible things to the survivor. You know, your husband's a good man. He wouldn't do these things that you said he did. Why are you lying? Why are you saying all these awful things about him? And was really pressuring this client to retract some of the statements that she had made. So you want to take that opportunity to just sort of hit the pause button for a minute, and if you're using interpreters or if you're having documents translated, have a conversation or in some way that, to the extent possible, that allows the victim to be making an informed decision about who's being used. And then, of course, we know that minors are significantly overrepresented in terms of who is being victimized and targeted for sexual assault. You know, most sexual assaults happen when the victim is between the ages of 12 and 24, and anyone who is under the age of 18 would trigger a mandatory report of child abuse. So you'll want to know both what privacy rights and protections minors do and don't have, and also at what age may a minor consent to care. And much of that is just set out when it comes to minors in terms of the consent laws are very clear. For the most part in Oregon statutes, but you'll want to know whether this minor may consent to the care, whether the care can remain confidential from the minor's parent or guardian, and then of course also when it comes to releasing documents, who may give consent. And we've mentioned a number of times, particularly for survivors in rural communities, there's some heightened privacy risks, and being careful about what information you share. I gave some examples at the beginning in the healthcare context of talking about a patient in the hallway or leaving information on a home phone when a patient's requested that it be communicated to an office phone or to a cell phone. Whether it's texting, I don't know if any of you are communicating with patients in that way, but thinking both about how the information is being shared and also what information is being shared. And something that could be very inadvertent, like, that you might think, oh, no one's going to know. I'm sure the physician who posted on Facebook about her patient who was always coming in late for appointments, or canceling them at the last moment, and who had had a prior stillbirth, wasn't thinking that anybody was going to recognize that patient. But of course it does happen. And even saying, oh, I took care of a victim today who has 6-week-old twins, may in a small community be personally identifying and may reveal who in fact the patient is. And then thinking about wherever it is that you're providing care, is there some kind of a private waiting area? Again, in rural areas in particular, everyone tends to know each other. Is there some privacy, especially for those of you who are being called out and may have several hours of driving to do before you arrive at the facility to conduct the medical forensic exam? Is there somewhere confidential that the patient can be waiting while they're waiting for the care to be provided or for the exam to be conducted? And then also, again, from the privacy perspective, think about whether there are any alternative exam locations are an option. I know that some of the family justice centers are looking and hoping to be able to have on-site medical forensic exam equipment and be able to have them conducted there. And depending upon what equipment you need and the cost, I know can be a huge barrier, but just something to think about and potentially to work towards in your community or the communities that you're serving. And then also, because we know that many of you travel long distances to see patients and maybe traveling to different hospitals, it's not like you're necessarily just on shift and available when a survivor comes in for a medical forensic exam, to be thinking about what patient documents you may be taking with you and how are you transporting them, or that being if you are, for example, having forms or files or anything like that, information that has to leave the facility, is it in an envelope or in some kind of a cover so that no names are apparent? And just always urge folks, never leave anything in your car, even when it's locked. For anyone who's ever had their car broken into, you know how insecure space that really is and how quickly somebody can break into your car, and you don't want that information inadvertently being compromised. So those are some tips that we wanted to share. And then just we want to tell you very briefly about our technical assistance privacy project. As Carol mentioned at the beginning, we are funded by the Office on Violence Against Women, who we thank for supporting our work in this webinar in particular, to provide technical assistance for OVW grantees, so for organizations and agencies, individuals who receive funding from the Office on Violence Against Women. And we provide our technical assistance, by telephone. We do research for people. We help do analysis, and also to make connections and to provide referrals. I do want to underscore that we cannot represent any of you individually. We cannot give you legal advice because that would be establishing an attorney-client relationship, and that's not something that we can do under our technical assistance work or our technical assistance projects. But if you are a partner on an OVW grantee, if you're eligible to apply for an OVW grant, or you currently are receiving funding through the Office on Violence Against Women, that we are here as technical assistance providers. We have cited in this PowerPoint and in our presentation today a number of statutes, and we always want to make sure that any information that we have provided that anyone is relying on is current. And so we do ask that our information is copyrighted, that if you want to use any of it, we're always very agreeable about letting folks use it, but we want to make sure that you are working with the current versions, that we know how it's being used and for what purpose and for whom. And so please, if you do want to be able to use any of the materials from the presentation today or from this PowerPoint, that you request permission. And lastly, but certainly not leastly, leastly is not even a word, we want to thank you and for the work that you do and being our partners in this work. We know just what critical services you provide to survivors, and that you don't always get the acknowledgement that we would hope that you would for your work. So know that we here at the Victim Rights Law Center just are very happy and grateful that we can do this work in collaboration with you. So our thanks to all of you for participating today, and know that we are both here in gratitude and to provide support to the extent that we can. And our thanks to Nicole and to the Oregon Attorney General Sexual Assault Task Force, and of course to the Office on Violence Against Women for giving us this opportunity to be with you. So thank you. And
thank
Carol,
you, everyone.
All right, and we'll sign off now. Take care.
Bye.